that we still need to finish on time now.
What is the difference? Just 1 week.
Exactly, just 1 week.
Okay. Group 11 is what? What is the title of their seminar paper?
Oh, good evening, sir. Good evening, sir. The title of our seminar paper is The Mental Basis of Civil Liability, Intention, Negligence, and Recklessness.
Okay. So we took the criminal aspect, criminal counterpart last week.
Yes, sir.
So quickly. What we just need to know from you, address these issues from your paper. Okay?
Okay, sir.
Does intention or recklessness or negligence has the same meaning, whether you are talking about criminal proceeding or civil proceeding? Secondly, which of the three concepts is more in use in criminal as opposed to civil proceeding? For example, we had last week that because of the presumption that mens rea must accompany acts as a general rule to constitute a crime, hardly do you find negligence being the basis of criminal liability, even though the word hardly is just the correct adjective to describe it, because we know that there are strict liability offenses, which some people will address us about. What is the situation in civil law? Say in the law of tort. Generally, what are the differences that you can bring out in terms of the treatment of recklessness and intention and negligence in civil as compared to criminal proceedings? So go to where you address those issues and talk to us about your paper, about what you said. Okay? So that we can make progress as fast as possible.
Okay, sir. Okay, thank you, sir. My name is Precious Sparkle. I want to know if my fellow colleagues are in the house this evening. Please just indicate by saying yes if you are here, so that we can get into the cross of the matter, like Prof said. Okay, we have Favor Chinechere Tochukwu. Is she here?
I'm here.
Okay, she'll be the one speaking on intention, Prof. We have Omotayo Tuluwani.
I'm here.
Okay. Omobalaji Abigail.
I'm here.
Abigail, yeah?
I'm here.
Omobalaji.
Yes, sir. I'm here, sir.
Okay. So 4 of you, Abi?
No, Stanley Agbojato. Stanley.
I'm here, President. I'm here.
Okay.
Who are those making noise now? Let's make progress as quickly as possible, please.
Okay. Thank you very much, Prof. Okay. So I'll be speaking first before my colleague will take over on intention. I just want to quickly point out that there is a disparity between civil litigation and criminal litigation or criminal action. In a civil action, a lawsuit is filed by a private person other than the government, and against another private person. The plaintiff a defendant who loses in a civil action does so does not face any risk of imprisonment or may face risk of fine, but does not go to prison like in a criminal action. In a criminal action, the onus is always on the prosecuting counsel to prove his case beyond all reasonable doubt, while in a civil litigation, it's on the balance of probability or the preponderance of evidence. And we said that in a criminal action, the defendant, if found guilty, may face the risk of incarceration or fine, any other term. And then it's always prosecuted by the state, local government, the state government, or the federal government, as the case may be. A plaintiff in a civil case may need only to prove on the preponderance of evidence, that the 55%, 51% certainty that the defendant was in the wrong, compared to the burden in a criminal case, which is always on the prosecuting counsel to prove this case beyond reasonable doubt. So we have intentional thoughts, we have by the defendant, such as misrepresentation, fraud, lies. Sorry, I had a call. Okay. The plaintiff must prove that the defendant purposely engaged in certain conduct, for example, by offering evidence that the defendant has spread false rumors, that the defendant engaged in a crime, knowing that rumors were false. Now, note, a civil action involves intentional conduct by the plaintiff. The plaintiff in many civil cases alleged that the defendant acted negligently and that this negligence caused their injuries or loss. In such cases, the plaintiff need not to show any intent at all on the part of the defendant. The defendant must show that there was a duty of care and that there was a breach of that duty and that there was a resulting damage. And then we have liability. Under civil liability, we have vicarious liability, we have strict liability, and then we have product liability. And we all know that under the concept of vicarious liability, there is the master-servant relationship, and there is also the independent contractor. And anyone who does something through another under the master-servant relationship does it through his employer or through his boss. Hence, the legal aphorism, qui facit passi, qui factum quasi faci. He who does something through another does it himself. Then under the rule of Ryland and Fletcher, which is also strict liability. Then we also have product liability. The concept of product liability in civil liability connotes the fact that it involves if there is a deficiency in a particular product by the manufacturer cannot in turn say that he's not aware of such defect in the product. And if there's a resulting damage in the defect, maybe the consumer took the particular product and as a result of that suffered any damage or loss, the manufacturer will be held liable. That was a locus classicus of Greenman and Huber Power product, where the plaintiff suffered injury as a result of a particular product. And then when he sued the manufacturer was arguing on the ground of timely notice that the suit has been barred as a result of timely notice, that there was no timely notice. And then the House of Lords said that those who go to buy a product from a particular business are not aware of business practices. So whether the issue of timely notice or no timely notice does not foreclose the fact that the plaintiff has suffered a particular loss or damage and has by virtue of right has entitlement in law to get compensation for his loss. That was in the case of Greenman and Huber Power Product Incorporated. Now, under the Civil Code of 1769, the civil proprietor failure of the buyer to give the seller notice of a breach of warranty within a reasonable time precludes liability. That was the argument of the manufacturer, that because of the fact there was no reasonable notice, they are precluded from instituting an action. But the court in their wisdom said no, that because the injured party is generally unaware of business practices justifying such rule, is entitlement to compensation. So from the evidence, it can be shown that the manufacturer placed a product on the market knowing that it is to be used without inspection for defect. One, that the manufacturer placed a product on the market. Two, knowing that
My
it is to
brother,
be used
please leave product liability. If product liability is not a type of liability for our purpose. When you are talking about strict, fault, absolute liability, or background liability, you don't bring in product liability. Product liability is a thought. It's not a type of liability. It's not a broad category of liability. So just leave product liability from your discourse. And I think that some people are coming to discuss this type of liability again. It must be one of the seminar topics that have not been delivered. Go straight to intention, recklessness, negligence in civil action.
Okay. Okay, no problem. My second will speak on intention, while I will talk on negligence again. Please, a favor to Shuko, you have the floor.
All right. Good evening, class. Good evening, sir. Favor to
Good
Chuko
evening.
here. I'll just move on. I'll just move on to intention. What is intention? Intention here, we're talking about the civil state, the mental in civil liability. We're done with criminal. So in civil liability, it refers to the mental state that is directed towards achieving a particular result. So it's a state of mind in which a person aims to bring about a particular result. Someone defined or described intention as having the foresight of a consequence which is accompanied by the desire to do them. So with that description by Salmond, we have two elements. Which one of them is the cognitive and the volitional? Cognitive is that knowledge, having that knowledge of what one is doing, like an actor or the performer, the person doing it. He has the knowledge of what he's doing, and volitional is the desire to achieve that particular result. Also, Glavin Williams talked about intention and says it distinguished it between the direct and oblique intention. That direct intention exists where the actor desires that consequence, while oblique is indirect. So it's a virtual sensitivity that the actor foresees when he's doing that act. Like doing that act, he already knows that this is going to happen, whether he wants it to happen or not. It's already there. Why for direct, he knows that it's going to happen and desires that it happens. Yeah. So we move on to Nigerian legal scholars, where they defined intention as the willful commission of an act, like you willingly commit an act and is likely to infringe on another person's legal rights. Another thing we looked at is Abiola Sani, when he said that intention in the civil context is construed from the totality of circumstances surrounding a person's conduct. When you look at the person's conduct, the actor, in this case, the person who committed a crime, the totality of the circumstances, how he carried it out. Later, we're going to distinguish between motive versus intention. Let's look at some few cases. In Letang and Cooper, the court drew a sharp distinction between intentional and negligent acts, holding that where injury results from negligence and not intention, the appropriate remedy lies in negligence and not trespass. Also, intentional torts require that the proof that the defendant acted with the purpose of causing the consequence or he knew with substantial certainty that the consequence would result. So when the defendant knows that, oh, this thing I'm doing is going to result in that harm, like it's seen in their deliberate conduct, you know that, okay, it speaks to the fact of intentionality in doing that crime. Also in Igbokwe and University College Hospital Board Management, the court also distinguished between negligent and intentional conduct, holding that for certain torts, such as trespass or person or land, intent must be proven, that the deliberate action was there, that intent was there. I have a lot of cases here, but because of time, I'll just move on. There's another
We will read them.
Okay.
Go on, we will read them.
Okay, there's this interesting case I'd just like to talk about. It's an English case of Bradford Corporation and Pickles, where
Yes,
yes, sir.
Yes, go on.
Yes, where the defendant his action, it was malicious. The action was malicious, but because it was legal, the court it was permissible by the courts because it was legal. It was with regards to water supply, and he was disrupting the water supply in his land just because he wanted to raise the amount of the land, that the amount of the land should be high, something like that. Then the court, not something like that, that's it. Then the court held that because he has a right to the land, he can do that, though the intention was malicious, but because his actions were legal, it was permitted. Now, the role of intention in determining liability. In intentional tort, courts may award not only compensatory damages, but also aggravated and exemplary damages as a form of denunciation, like as a form of repudiating that action is bad, as a form of saying that this action, condemning that action. So when intentionality is found, when intentionality is proven that these deliberate actions, it was intended to cause this harm, the court always had a special damages or exemplary damages to it. So a scholar has stated that the presence or intent of knowledge of harm significantly increases the likelihood of punitive measures. In Winson and Ringo, the court stated that intention to perform the act, whether it's a physical contact, is sufficient for liability in battery. They do not need to prove any other thing again. Just proving the intentionality, that the intentionality is there, is sufficient for battery. Also, in a Nigeria case in Ojo and Garoro, the court also stated that the defendant's awareness of the natural consequence of their acts suffices to establish intent. Now, let me quickly jump to motive versus intention, because this is quite confused and the court has distinguished between both of them. While intention relates to the deliberate act of bringing about a result, motive refers to just the reason for doing so. Why did the person do that? Just the reason for doing so. And that case, I also cited Bradford Corporation and Pickles. It's very, it's needed also here, applies also here. In Harrow versus Maloney, the court held that motive is irrelevant to the question of intention. The distinction is echoed in tort law, where even a benevolent motive does not excuse an intentional wrong. Even if your motive of doing so, the reason for the person, the actor for doing so, it does not in any way excuse their intentional wrong. Also, in Amugbo and Ogu, the Supreme Court held that the defendant voluntarily committed an act that interfered with the plaintiff's rights, and the motive for doing that is immaterial. They don't need to check the motive, if it was right or wrong. If their reason for doing so, if they had a good intention of doing so, that it was wrong. Also, if you also look, it was wrong. Okay, I think I've spoken to the facts quickly about this. So in rounding up, I'll just say that intention
I'm
serves as
sure.
a
I'm sure that we have delegated some people also to talk to us about motive and malice. If I remember the syllables very well.
Okay, sir.
So I haven't spoken about intention. You have done your bit.
Thank you, sir.
Let other people talk about motive and malice later, and its relationship with liability for consequences.
Okay, sir.
Some people, other people will talk about it. So we've listened to you on intention. Is that all? Is that all
I just want to conclude with this, that intention serves as a cornerstone and it determines intention serves as a cornerstone and determines in helping or establishing fault and justifying the imposition of legal responsibility. So it's a cornerstone in civil liability. So, and when it is found, it suffices for proving wrong.
Okay. Are you suggesting that as an element of a wrong, intention is possibly more important to civil liability than to criminal liability? Are you by any way suggesting so?
In my opinion, because criminal litigation, you have to prove beyond reasonable doubt. Apart from just the intention, you have to still prove other factors. So I think it's more appreciated with civil cases.
You think so?
Yes, Your Highness.
How many thoughts can you possibly commit without intending them? And how many crimes can you possibly be adjudged guilty or liable of, or guilty of, without actually intending them? I'm trying to interrogate your view. The intention is a more crucial element, a more crucial mens rea for civil wrong than for crime. I think that is the other way around. It is the other way around. The number of civil wrong that you can be liable for without necessarily intending the consequence of your act are much more than the number of criminal offenses you can be guilty of without intending the consequences of your act. As a matter of fact, the general rule will appear to be that you can't be convicted of a crime unless there's some mental element. That's the general rule, even though we know that there are strict liability crimes. Whereas in civil wrong, it does appear as if on the part of the defendant it's a ubi just remedium. If we are looking at it from the perspective of the defendant who has suffered the harm, if he has suffered the harm, the tendency is to want to accord him a relief, some form of remedy. And in the course of doing that, you have all manner of conduct considered wrong, just to ensure that the victim of an act gets a relief. So intention, to me, would appear to be a more serious element in criminal law than in civil law. You can be liable for many civil wrongs without necessarily being without necessarily intending the consequences that are arising from your conduct. But rarely, or less commonly, does the law hold you responsible for a crime when your act was not accompanied with some guilty mind. Okay? So let's go to, did you people discuss recklessness?
Yes,
we
no,
did, sir.
sir. I'll be speaking on recklessness, sir.
Okay.
Yes, sir. Okay, so
look, Okonkwo, please mute your mic.
Sorry, I didn't get that.
I said, let's go on.
Okay. So we discussed recklessness as the third mental basis of civil liability, and basically what we regarded recklessness to be is an awareness of risk, yet a disregard that results in harm or damage. And then we recognize the fact that with respect to recklessness, there's a higher degree of liability than negligence, and a lesser degree of liability than intention. So generally, there is higher degree of liability in recklessness, and that's why usually in recklessness, persons that would sometimes have escaped liability becomes liable in situations where recklessness is proven. We have examples of where an action would have been said to have been started by an action of a government agency, and then if it is proved that recklessness as a mental basis, such actions can still render government agencies liable. We also looked at the Good Samaritan statute situation, where a health worker who is said to have been to have offered services of rescue to a non-patient will have not been liable with respect to negligence if such person is found to have acted recklessly. Such health worker becomes liable. We also look at situations whereby in some jurisdictions where a landowner cannot be liable for negligence when recklessness is established as regards a trespasser, when there's a trespasser to the landowner's land, such landowner becomes liable. And we consider that in America, for example, there are situations where under the tort law of America, the recklessness of a tortfeasor can cause the plaintiff to be entitled to punitive damages, although there is no difference in the quantity of punitive damages awarded for recklessness rather than malice. So in such situation, the plaintiff may still desire to prove maliciousness because in American bankruptcy law, debts incurred through willful and malicious injuries cannot be discharged in bankruptcy, but debts incurred through recklessness would ensure that such party is liable. So yes, we looked at elements of recklessness in civil cases, as already stated in the definition. The very first thing is that there's awareness of risks. The defendant must be aware or should have been aware of a substantial risk of harm to another person or property. And also we have the disregard of such risk. So after being aware of the fact that there's a risk, that's the defendant
must be aware, or the defendant should be aware.
Sorry, should be aware. I'm so sorry for the use of words. It should be aware that there's a risk. And then goes ahead to disregard.
What then is the difference between recklessness and negligence? If recklessness is punishing the reckless person for not being aware of what he should be aware of.
No, I'm not saying that he shouldn't be aware. We're saying that he should be, he must or should have been. Those are like two different situations. So he must be aware or should have been aware.
Is it better to say the defendant is or is deemed to be aware? Is or is deemed to be aware? When you say the defendant should be aware, then you are talking about a duty of care. You are talking about, you see, the major difference between recklessness and negligence is that recklessness is a state of the mind. Negligence is not a state of the mind.
Okay, sir.
Okay, sir.
Is not
hello, sir.
Yes.
Okay. Will it be appropriate to say that recklessness is more willful, more purposeful, and negligence is more like an omission?
That would be talking.
What the jurists say is that if you are aware, okay, of a risk, and you nevertheless take the risk, not burden yourself about whether your fear turn out to become reality or not, then you are reckless. Okay?
Okay,
but you are negligence if you fail to put yourself in the mental state that a reasonable person will put himself.
Okay,
Do
sir.
you understand? So when you
Yes.
say he should be aware, that looks like a language of negligence. Okay?
Okay. Yes, sir.
But when you say he is aware or is deemed to be aware, there is a difference between being aware and being deemed to be aware. Okay? But we categorize the two as being the same in the circumstances. Okay? So
Okay, sir.
recklessness is a state of the mind. The law is saying that you knew that this will flow. This is the likely consequence of your act. But you just didn't care. That's recklessness. Okay? In negligence, you will be saying you didn't know. But the law will punish you. Why will you not know? Are you not a human being? Are you not a reasonable person? If you are a reasonable person, you ought to know. So the punishment in negligence is for your failure to know what you should know. But recklessness is for your carelessness, not bothering about what is possible or what is probable consequence of your conduct. Not that you don't know. That's the difference between the two.
Okay, thank you, sir.
Yes.
Thank you very much. Okay, so sir, as a follow-up to your explanation, I want to ask if a situation whereby a man has a dog that is very dangerous and then does not chain the dog, and maybe someone just comes into the compound and the dog bites the person, is that a situation of recklessness, sir?
Of course. That is more like recklessness than negligence. That's more like
Very well,
reckless.
sir.
Somebody gave an example. There's one example I was reading somewhere. It says a driver who is distracted and causes an accident may be considered negligent. But a driver who speeds through a red light, knowing it could cause an accident, will be considered reckless. A driver who is distracted. Oh, I didn't see the light. I didn't see the red light. The policeman was distracting me, and I saw the other vehicles by my side moving. But if the position is that I saw the red light, but I was too much in a hurry to wait because I wanted to do something, he gives a reason, you understand. So he knows the consequence that vehicles coming from the other side, for whom he ought to have stopped, would, in compliance with the light that will show green as at the time it's showing him red, they would have proceeded. And so he knows that unless he's extremely lucky, he was going to have a collision, head-on collision with another vehicle. But he was too much in a hurry to even consider that as a risk he should avoid. So if the accident occurs in that type of situation, he could go in for recklessness. Okay? But if his argument is that anybody who is approaching traffic light ought to observe it, his argument is that he was distracted and the vehicle immediately before him was moving. Because he was distracted, he didn't see the red light. That's negligence. Okay? Because he ought to have looked at the red light. He ought to have looked at traffic light. He didn't. That's negligence. But he saw the traffic light. Nevertheless, he took a risk that, well, maybe the vehicle from the other side will notice that there is somebody who is not observing the traffic light and will wait. Okay? There is 90% probability that it is the same light that one will be looking at. And if the light shows him green, he will go. He will not observe you. Okay? So you took a calculated risk because it is more important for you to arrive at where you are going in a short while than to obey traffic light. So that one is recklessness. So those are the type of example. Something is a very thin line. The line is very thin between recklessness and negligence in factual definition. But in legal consequence, the funny thing about it all is that recklessness is closer to intention than to negligence. Because whereas, whether it is criminal law or civil law, recklessness and intention connotes some state of mind. Negligence simply means that you didn't even put yourself in any state of mind at all. As far as the consequence of your act is concerned, you did not put yourself in a state of mind that a reasonable man ought to put himself. That's what is negligence. And that's what you're either being punished for in crime or you are being damnified for in civil wrong. Okay?
Yes, sir.
So what do you have to,
Okay,
what
sir.
do you want to add to negligence?
Okay. My other colleague will
Negligence,
take it over.
yes, negligence.
Okay, sir. Negligence. Prof, you've said it all, but just to consolidate on what you've said so far, negligence is the failure to exercise reasonable care under a similar circumstances where a person ought to exercise reasonable care and it results in damage. And there are three elements. Because of time, we just go straight to the three elements one needs to prove in an action for negligence. The first is a duty of care, and there is a breach of that duty on the part of defendant, and there is a resulting damage. In the case of Longeley Hyon and Co. and McMullan, the court was of the view that not every act of carelessness or negligence is actionable under the tort of negligence. They stated in strict legal analysis, negligence means more than heedless or careless conduct, whether in omission or commission. Now, to succeed in an action for negligence, the first thing to prove is duty of care. The first question to determine in an action for negligence is whether the defendant owes the plaintiff a duty of care or the claimant a duty of care. In a general duty of care would mean that it's foreseeable that if the defendant does not exercise due care, the claimant will be harmed. The concept of duty of care was first raised in the locus classicus of Donegal and Stevenson, where the legendary Lord Atkin institutionalized his neighborhood principle. In his dictum, he said, the rule that you must love your neighbor becomes in law, you must not injure your neighbor. And the lawyer's question, who is my neighbor, receive a restricted reply. You must take reasonable care to avoid acts or omission which you can reasonably foresee will likely to injure your neighbor. Who then in law seems to be my neighbor? The answer seems to be those persons that are so closely or directly affected by my act or omission that I ought to reasonably have them in contemplation when I'm directing my mind to those acts or omission that are called in question. So in that case, a manufacturer of a ginger beer sold a product to a retailer, and the retailer sold it to the consumer. The consumer purchased it, drank the beer. There was some decomposed particle of snail in the beer, and because he didn't know there was a decomposed particle of snail, he got healed, he was hospitalized, and then he sued for negligence. And then the defendant alleged that they hold no duty of care to the plaintiff, but the court said no. That was where the principle of negligence and the neighborhood principle was institutionalized. The neighborhood principle was updated in Capro Industry, PSC, and Dickman, which involved 3 tests to determine the existence of a duty
My
of
friend,
So,
we are not in the third class. You have done well. Well, we are not. You know that even in thoughts, they will tell you that negligence has 2 perspectives. Negligence as a thought and negligence as an element of a thought. We are concerned with negligence as an element of a thought. Okay?
yes,
And I would have loved your folly if what you have done is to tell me what are the thoughts that you can become liable for because of your negligence. Apart from negligence itself, what are the negligent acts that can result in thought, and what are the different type of thoughts apart from negligence itself? Okay, then what are the thoughts that you require recklessness to establish liability, and which are the thoughts that it is only intentional act, okay, that the law of thought seeks to provide relief against, okay? But what we just need in a jurisprudence class is the distinction between the 3 terms: intention, recklessness, and negligence, and whether the distinction would lie in the same way in both civil and criminal law. Okay? We will go through your papers and compare them with the paper presented for criminal law, and see how much knowledge you would have acquired. But our task is a straightforward one. The 3 terms, which of the 3 terms can you actually regard as a mental state? Why is which two of the 3 terms will you consider to be a degree of mental state? Which one has nothing to do with state of mind? And between civil law and criminal law, which of the 3 will often be required in order for liability or guilt to be found against a doer of an act? That's all we are interested in a jurisprudence class. Okay? We are not teaching thought. Okay? Can we move to seminar paper 12 now? Thank you very much for your presentation. We will read and gather knowledge. Okay?
Thank you,
If it
sir.
comes in the exam, I'm not interested. If it comes in the exam, we are not interested in specifics. We just want to show that the layman understanding of those 3 terms might be different from the way law sees them. Okay, that's all we want to establish in a jurisprudence class. So, paper 12. Paper 12. We said we are getting up to paper 13 today. So if we must get up to paper 13, we can't spend too much time on paper 11. Paper 12, 30 minutes. Paper 13, 30 minutes. What's paper 12 all about?
Yeah, good evening, sir.
Yeah, not sir.
Yeah, good evening, sir.
Good evening.
Yeah, we're taking paper 12. The types
What
of
is it all about?
criminal liability.
Okay.
Fault, act or omission. Absolute, strict and vicarious liability.
Okay. Do we
That's
also
our
have a civil law component of this? Class captain, what is paper 13?
Civil component.
Oh, the civil component of it. Very beautiful.
Yes,
We are
sir.
going. Okay, so types of liability: fault, absolute, strict, vicarious in criminal law.
Yes.
Go on.
Yes, we're talking about criminal liability, fault, act or omission, absolute and strict, and vicarious liability.
Yes.
So our paper is paper 12, and we're going to be looking at the introduction to criminal liability, the elements of criminal responsibility, physical elements, mental elements, intention, recklessness, negligence, accident, unconscious stroke automatism, concurrent or physical or mental elements, judicial interpretation of criminal law, then burden of proof. Our part 2 talks about strict and absolute liability. We'll be looking at the essentials of strict liability, concept of strict liability, judicial decisions, statutory and in strict liability, criticisms of strict liability, general concept of absolute liability, difference between strict and absolute liability in Nigeria, types of absolute liability as a legal accountability, element of absolute liability. Our paper 3 will be talking about general concept of vicarious liability, element of vicarious liability, the concept of vicarious liability under criminal law, rationale, judicial justification of vicarious liability, relationship between that may give rise to vicarious liability, tests for vicarious
You are
liability.
still on introduction, my friend. You have only
No.
30 minutes to talk to this thing. Address us on fault liability. What does
Okay,
fault
sir.
liability mean?
Okay,
And
sir.
why is it that 90% of criminal liability will be fault liability? Talk to us. Check wherever
Okay,
that is discussed in your paper. What
okay,
is
sir.
fault liability? And why is it that 90% of criminal liability will be fault liability?
Okay, sir. Fault liability, actually, I want to look at section 24 of our criminal code. Section 24 specify that. I'm coming, sir. Section 24 talks about paragraph 3 talked about unless otherwise expressly declared, the motive by which a person is induced to do or omit to do an act or to form an intention is immaterial so far as regards criminal responsibility. Section 24 talks about a man shall not be liable, shall not be guilty
That
of.
is the one we need. Yes.
A man shall not be guilty of an offense except there's an intention. Except there's an intention. And without that intention, that person will not be guilty of that offense. That's our criminal code. Section 24 talks about that fault liability, that there must be a fault in the part. There's a case of Solomon Adekunle versus the state, where the police officer shot a moving bus, a passenger bus that was moving, and he killed somebody and injured 4 persons. And he was claiming it was an accident. They said, no, that your action, there's a fault in it, because you should know that this is a passenger bus. This is a passenger bus. It cannot be an accident, accidental discharge. You saw that this is an accident, and you open fire on a passenger bus that carries passenger, innocent passenger. And a lady there, Alice, died. The court held him liable for his action. And we'll look at, when it comes to criminal liability, we'll look at the elements of criminal liability, which is the actus reus. That's the physical element and the mental element.
But we have been told by paper 10 people, that one is an Oyinbo categorization now.
Though our criminal law does not.
Application.
Yes, it
Yes.
does not. They didn't mention mens rea or actus reus, but in a way that having an intention, the guilty mind is very, very important in every criminal case. Without a guilty mind, the person cannot be held liable for an offense.
So concisely, how will you define fault liability in the light of the provisions of the law? How will you define fault liability?
Fault liability definitely can go in two ways. Fault liability can go in two ways. Can go when there is a mens rea and actus reus, that the person has a guilty mind and there's an action that is prohibited by law. Then the second way is when the person is he didn't have a guilty mind but is held by strict liability. He's strictly liable because the law says.
Well, that is fault liability is more or less like the near opposite of strict liability. See, fault liability, the opposite of fault liability is absolute liability. If somebody is holding you responsible for the consequence of your conduct, irrespective of your mental state, irrespective of your mental state, your negligence, nobody wants to know how it happened, but the mere fact that it happened directly or indirectly through you is what we are punishing you for. That's absolute liability. But it rarely happens. The liability that is very common is the fourth one, where it is not sufficient for the prosecutor to show that your conduct resulted in the wrong. He must also show your mental connection.
Yes, sir.
Okay.
Sorry, sir. That section 24 that says a person is not criminally responsible for an act or omission which occur independently of his exercise of his will.
Yes.
Or an event which occur by accident. That means if his will is there, he knows that this thing is going to hurt somebody and he goes ahead. Like in the case of Aru versus Nungu, where he uses an axe. He wanted to use the sharp side to cut his brother. But on the second thought, he turned his other side and used the heavy side of this and hit the brother on his head. And the brother still died. The court held that there was an intention to cause grievous bodily harm. And he was found guilty of that. So I believe the fault liability is that having that intention to cause a harm or cause somebody else a harm or breaking the law.
Okay. Well delivered.
Yes, sir.
Fault liability is when the conduct not only resulted from your act of omission, but yes, it's accompanied by a particular required guilty mind.
Yes, sir.
So when a guilty mind is not required, okay, when a guilty mind is not required, then the liability is not fault liability. It will be any of the other liabilities.
Yes,
it will be any of the other liabilities. So that is fault liability. And we said you'll find that in 90% of the occasions when a person is found guilty of a crime, his actus reus, his physical conduct, is accompanied by some guilty mind. Okay?
Yes,
so
sir.
That's fault liability. Did you discuss absolute liability?
Yes, we discussed absolute liability.
So what is absolute liability?
We said that absolute liability is often referred to as also often looked at as strict liability, but the difference is that absolute liability
Can I comment on? Can
Absolute
I
liability is, on
say
the
you
other hand, is even more rigid. It means that once the prohibited act is committed, no defense are allowed. But in strict liability, defenses are allowed. But in absolute liability, they don't allow you to defend. There's no defense. The person is automatically held
Somebody was
liable.
trying to contribute. Somebody was trying to contribute.
Okay, it's my colleague. Yes, you can continue. Laide, you can proceed.
Yes, I was trying to say something since he was looking for where it is on absolute liability, and he has said something on that. So it's just that absolute liability is a doctrine, that a legal doctrine that holds individual or entities responsible for their actions, and this is without requiring proof of intent or negligence, which means that in absolute liability you don't need to prove whether you have intention to commit the offense or the negligence. You individuals are responsible for their action without requiring intent or proof of intent or negligence.
In your own view, is absolute liability a proper type of liability for criminal proceedings, in criminal law?
Sir, when looking at absolute liability, I believe absolute liability is not really used on every fault. It's basically where the welfare of the state, the welfare of the people, of the community, is a safety of the community is at stake. That is where the law brings in absolute liability. Like in
Can you
cases
give
of
us one
health,
example?
like food products. What about products, food items?
Yes.
Food items and health matter, anything that is result to health matter that could be hazardous to the society. The law always make an absolute the doers will be absolutely liable for such
Yes,
did you notice any pattern of punishment? Because you see, if it could be that on such rare occasion, when a person is convicted on the basis of absolute liability, it could be that more often the punishment is different from
the punishment is
that
mostly
of
a
false
fine.
liability.
Mostly they put a fine instead of going to prison. They don't really put imprisonment for absolute liability.
Okay.
They might put a fine. The person might be made to pay a huge fine. You understand?
Okay.
Or do some public restitution or something that will help the public.
Okay. Okay. Yes.
In my own opinion, I believe that absolute liability I support the punishment for absolute liability because it's basically to promote safety and accountability, to make people responsible and to hold them accountable for their action, and to make people to be more conscious about their activity, their actions, and make sure that it does not affect the safety of others. So I'm in support of the concept of absolute liability, sir.
Okay. Now, there is something we didn't talk about when we are looking at theories of thought. I don't know whether it is this year or last year. Don't you think that it is better for entities and individuals to be compelled to insure against non-fault liabilities? Shouldn't the absoluteness be based on the duty to insure or be cured by insurance?
Why the insurance is a It's like
So
a
it will build
restitution
into,
that
it
is
will be
replacing
built into the
the
economic cost
damage.
of running their business.
The insurance basically is to benefit the organization that causes that problem, that causes the hazard. Most of the time when you insure a product and there's a problem, the insurance coming to pay.
No, there are several
But I don't think
categories of
the
insurance.
insurance might also come into, the insurance might also pay that same amount to the government. If the government makes that offense an absolute offense. So the company might not really feel the burden if there's an insurance covering such absolute liability.
And maybe it is more appropriate
But
for
the company might still be careless.
Maybe it's more appropriate for civil responsibility. Do you understand?
Yes, sir.
Okay. Let's go to strict liability. When is liability said to be strict?
Strict liability means that a person can be held responsible for an offense, even without intention or negligence. But some differences may be available, defenses may be available.
Okay.
Those defenses could be like unforeseen circumstances, act of God, beyond their control. But generally, strict liability was like some speakers have spoken in some of the top classes earlier, that strict liability was established in the rule in the concept of in the case of Ryland versus Fletcher.
Ryland and Fletcher. You see, that's
Yes.
another issue. Strict liability as a thought is not what we are discussing in this class.
I know.
Strict liability is just a mid-course between fault and absolute liability. Absolute liability, no defense at all. Strict liability, some of the defenses that you readily present are not available. But there are still others. Even in the decision in Ryland and Fletcher, when you read it in the textbook in thought, they will still give you possible defenses.
That's true, sir.
But if it is absolute, there would not have been any possible defense.
That's true, sir.
Okay? So, when do you call a crime a strict liability crime?
A strict liability crime basically is when the law, the statute.
Yes? Hello? I'm not hearing you.
Sir, let me just try to say something on that, sir. I don't know, maybe it is network. So in my understanding, yes, strict liability strict liability crime occur when an unforeseen event occurred when it was caused by an act that is beyond beyond somebody's control, that beyond the perpetrator's control. That's when the offense of strict liability is established.
Well, you see, the thing with you people is that you like reading big books. But if you just take your basic Okoko and Nash, or any basic text, you find the definition, yes?
Yeah, I am back. So I was explaining something about strict liability.
Yes.
That strict liability, musically, when it's an offense, when the statute, or the laws of the state says that it's an offense, it becomes an offense, regardless of whether the person have a guilty mind or not. The person doesn't have a guilty mind, sir. If the person might not have a guilty mind, it might not be intentional. But if the law says you should not pass this road and you pass the road, you'll be made to pay the fine for it. And most strict liability, sometimes Me, I still frown at strict liability when the person is given imprisonment instead of giving the person a fine. I believe there's some you still they still want to impound your vehicle, and they still want to, so there's some jail time for it. Like somebody crossing the express road, not knowing that they don't cross there, that they're supposed to go and take a bridge down. You understand? It has occurred to me before, but thank God I escaped the. I pleaded with them and they listened to my non-intentional.
In Nigeria, the sickness is highlighted by the money you pay now. Abi?
Yes,
They will
sir.
take you to a corner and tell you that if you follow them up to somewhere, you pay this amount. But if you give them this amount now,
They'll let you
they will
go.
close their eyes to it.
So most those are the fault of our strict liability.
Anyway, I think the way criminal law texts explain strict liability offense, they explain it right from the couching of the crime itself.
Yes,
If,
sir.
for example, the statute says you are guilty of an offense for knowingly being in possession of something, the statute itself has indicated an element of fault. So if you have a defense that it's not my own, somebody just kept it with me, and I didn't know that this is what it is.
It happened in the airport most of the time when people are traveling. Somebody carrying cocaine can say, please help me hold this bag, please. Let me button my shoe. And you are holding the bag, and it's not your bag. Intentionally, you know it's not your bag. You don't even know the content of the bag.
And then
And
somebody open the bag and find the
as we find cocaine or something in it.
If the offense is anybody who is in possession of an article knowing it to be, then that offense is couched in a manner that you can only be liable if you are at fault.
If you know, if you have a
Because
knowledge.
the mental element has been put there. But sometimes you find statute couching it in a way that they don't give a damn what your mental state is. The mere possession of it itself is the completion of the crime. No
that is where
element is
our
required.
legislature should, when most of our laws, when they are couching it, they should put a lot of things into consideration. They should put a lot of things into consideration, like somebody that is unknowingly. That's why technology plays a lot of role. Like abroad, most of the airports, they have camera everywhere. Somebody that forgot a bag in the airport, they will know who has the bag. By the time they go back and play their video, they will see, okay, this person gave this person this bag. You understand? It will be shown clearly. So technology will vindicate that person.
There are some type of offenses that are very suitable for strict liability, like traffic offense.
Yes, sir. Yes, sir.
So it's our duty as students of jurisprudence to know that certain categories of offenses, they are suitable for strict regulation.
Yes, sir.
So that the fault of the doer of a conduct or omitter of an act will not matter. When that becomes the case, we say that even your negligence is being punished, contrary to the usual standard that is only your state of mind that will be punished. So when an offense is couched by a statute in a way that mental state is irrelevant, the prosecutor does not have to prove your mental state before you are convicted. It is said that the offense is a strict liability offense.
Offense.
Okay?
Yes, sir.
And strict liability is not commonplace in criminal liability. It's not commonplace in to find guilt in the trial for crime. Nevertheless, you have them. You have a few offenses, even in the criminal code. Then you have offenses created by other statutes, like traffic law and what have you, where mental elements are not required. The section couching the crime does not use any of those adjective of state of mind. Okay?
Yes, sir.
Like knowingly, recklessly, etc., etc. Okay, so that's strict liability. Yes. What of vicarious liability? And do you have vicarious liability in criminal law? Do you have it?
My colleague will talk about vicarious liability. Easy.
Good evening,
Yeah,
Prof.
what was your finding on vicarious liability? We all know
On
vicarious liability. Nobody would
Yes,
be
sir.
in this class if he didn't know vicarious liability. But
Yes.
is it ever possible to convict a person criminally
Well, yes, sir.
because
Well,
of vicarious liability?
yeah. Well, generally, sir, for vicarious liability, it's usually not possible to convict a person in criminal law, and that's because of the mind element that must exist in convicting a person under the criminal law. And so, where someone has carried out an action, and the law wants to convict the next person because I have a relationship with the offender, the law frowns at that. Now that's the general position because vicarious liability will largely apply to civil offenses. But there has been we were able to see some offenses that carry or are likely to have some vicarious liabilities applied to them. We saw offenses relating to, as has been discussed before now, road traffic laws. There are insurance laws that carry criminal liability, criminal responsibility, and so the law presupposes that regardless of the fact that the driver or the person who is in possession of the car at the time when the offense happened, the owner also has a liability attached in that circumstances. There's also issues around insurance. We saw issues around insurance to say that no person shall use or cause or permit any other person to use a motor vehicle on a road unless a liability which he may incur in respect of damage to the property of third parties is insured. And so the law is also giving a liability on a third party, regardless of the fact that you're not the one on the steering at the time when a harm happened. We looked at the rationale or justification for vicarious liability, and we looked at, we said that vicarious liability can be justified on the grounds of policy consideration and social insurance. And we referred to Lord Simmons and then Sir John Holt, particularly with reference to public policy. All that vicarious liability is trying to do or achieve is that there should be some level of sanity, regardless of the direct offender being present at the commission of the offenses. Our finding is that it may still be a very thin line for us to apply vicarious liability to criminal actions, but we think that it is still possible. It may be a hurdle to cross, but we think that there's a possibility that could apply. But for now, it's generally a civil offenses that carry vicarious liabilities. We did some analysis on the test for vicarious liabilities. We discussed the tortfeasor liability, special relationship test, and also the cost of employment tests. We're trying to find out what a court would look at for a claim in vicarious liability to succeed. We refer to the case of Ifeanyi Chukwu and Sole Bone Limited, where the Supreme Court held that for a plaintiff to succeed in a claim for vicarious liability, of course, this is a civil action, he must establish the existence of three elements to it: that the wrongdoer is liable for the tort, that the wrongdoer is a servant of the master, and that the wrongdoer acted in the course of employment. Now, for the first and second test, that's tortfeasor liability and special relationship, we can deduce the meaning from the name. There has to be that relationship, and then there has to be the tortfeasor. But I want to discuss the course of employment test, which is to the effect that the employee must show that he has committed an action.
Is vicarious liability limited to case of employment? Are there no other relationship that can bring about a non-actor being vicariously liable for the conduct of the actor? Is it only employer-employee relationship?
Yes, for us, we discussed just the three of them in our
sorry,
work.
in the
we
role
have
of a guardian and the ward and the guardian, if you are in a locus parentis, if your child commit a crime, the father can be liable or the guardian can be liable for the
Certain
offense
type
of the child.
okay.
Very, very well. Thank you, Mr. Gani. So these are offenses that could occur that would bring about liability.
So,
then we discussed
the aspect of your discussion that this class will take home is that vicarious liability generally is more suitable for civil responsibility. Is that not so?
Very well, sir. Very correct, sir. Yeah.
Did you discuss corporate criminal liability? Corporate criminal liability. I don't know whether we gave that one to another class.
Yes, sir. We are giving it to another group, sir. Yes, sir.
Okay. That's another interesting topic on that type of criminal liability.
Liability is
because
corporate.
There used to be controversy that a company cannot have a guilty mind. Therefore, you can't convict a company and all of that. And that, but in modern times, we are seeing the courts dealing with that controversy seriously. And it will be interesting to know what the position is today as regards the possibility of a company being found guilty of a crime and being penalized. So, on that note, I think
sir, there's still something in our paper I want the class to know.
Yes, what is it?
Yes, in our paper we looked at Belgium. That in Belgium, the criminal code mandates helping individuals in serious danger when it can be done without personal risk. So this duty, introduced in 1961, is enshrined in the Article 422 of their penal code. The failure to provide that aid in such situation is a punishable offense in Belgium.
Very interesting. There is a case my criminal law lecturer cited to me as a 300 level student. Akani and the state. Can anybody remember that case? That was the case where a house was put on fire by some criminals, and an old woman was in the house.
Okay. I remember the case.
People who hung around and did nothing. Some of
they
them
were
were charged to court.
They did nothing and they were charged to court.
Yes. And the court said, well, what offense are we going to hold them responsible for? So if you have a law like the Belgian law, they will be guilty of some wrongs.
Yes, because the Belgian law also looked at they talk about serious dangers. The person in need must be in a situation that is grave peril, particularly involving a risk of death or serious bodily injury.
Yes.
And they also looked at said ability to assist without personal risk. That the person too must be able to assist without risking his own life. Then the knowledge of danger. The person is required to assist must be aware of the danger, either through direct observation or by being informed by others. Then the punishment not for compliance, failure to help when the conditions are met can result in penalty, including imprisonment and fine. So in essence, the Belgian law strikes a balance by requiring assistance when it is reasonably safe to do so, but not impose an impossible or unduly risk burden on the individual to act as a rescuer. So I believe such law is humane. It has a human heart, and it also there's some situations where some see somebody in danger, you can help and you just turn away and walk away. Like in our town where you see accident cases where people are somebody fell down and is dying, and if that person is rushed to the hospital, he can be saved. This law can also play a very good role to save Nigerian in some accident matters. They say, I don't want to be involved. The people just walk away and the person will be bleed dead to death. So I believe our laws these are part of the things that could help to refine and rebuild our laws.
And to worsen the case, you get to the hospital, they will not even accept you in the hospital.
That is another thing. The doctors too. This kind of law should be binding on them.
Yeah, I think we should also recommend good Samaritan laws. Nigeria, we don't have good Samaritan laws. Sometimes when you help, you find yourself in problem. So we don't have laws protecting good Samaritans. So why would we expect somebody to come and assist when
that is
will
what I want
eventually
to
land
say.
into problem?
The concern is how to develop modalities for that good Samaritan law. How do you develop modalities for that?
Our Nigerian police are making it very impossible for us to do that. Once you help, you go to police station.
Everybody is working for survival. Even the police, when you invite them to come and help you arrest a criminal, the amount of money you pay to get them to come, sir.
Exactly, sir. Exactly, Prof.
Just leave us, leave Nigeria the way we are.
Hello.
We have not gotten to that stage. We have not gotten to that stage. I can assure you of that.
Thank you very much, sir.
So let's move to what are the civil people going to talk to us about? We have 23 more minutes.
Thank you, Prof.
The civil component. Can they start? Hello?
Hello, good evening, Prof.
Yes. You have listened to...
Good evening, class.
Yes, you have listened to the previous group. You've listened to what they had to say about fault, strict, absolute, vicarious, liability in criminal law. Let's listen to those things, those items in civil law now.
Our topic on civil liability fault, acts or omission, absolute, strict, and vicarious liability.
Okay.
Permission to recognize my group members. If down, Ezeka Iku Ngozi Blessing. Please, if you are there, indicate by responding. Ezeka Iku Ngozi Blessing. Are you there?
Class captain, take note. Ezeka is not around.
Obia Sylvia Chiwendo.
Yes, sir. Silva is here. Good evening, Prof. Good evening, class.
You're welcome.
Okay, Silva, you're welcome. Mado Abuchi Okoji Ndukwe. Mado Abuchi Okoji Ndukwe. Okay. Prof. Mado Abuchi Okoji Ndukwe is actually not available because of he's not strong. So that is why he's not here. I
So
heard
do you have a
Ngozi.
category of excused?
Yes,
For purpose of
I think
matching?
Ngozi sent a message that she's stuck on the road. That
And she
yes,
cannot open her phone and they join this class.
she said she will be joining on the road, but I've not heard her voice. Okay, our topic is types of civil liability fault, act or omission, absolute, strict, and vicarious liability. Me, I'll be talking on introduction. Oh, sorry, table of contents.
We don't have
table
time.
of contents.
We don't have time for table of contents,
We have
sister.
part 1, introduction. Part 2, we have absolute liability. We have part 3, we have part 3, we have vicarious.
Let me be asking you questions and you'll be answering me. We have listened to the definition of fault, strict, absolute, and vicarious liability under criminal law. Do you find any difference in civil law?
Sorry, Prof, you can come again.
We have listened to the definition of fault liability in criminal law, strict liability in criminal law, absolute liability in criminal law, and vicarious liability in criminal law. Do you think that the definitions for those terms under criminal law fits their meaning under civil law?
When it comes to civic liability within the framework of jurisprudence, that refers to legal obligations that are imposed on individuals or entities to provide redress for harm caused to others in private legal relationships. I have seen civil liability as a primary compensatory and redeemable in nature. Its function upholds the rights of individuals, and it restores balance in legal relationship and promotes accountability in social intercourse, in social interactions. So looking at from the contents of jurisprudence that I'm talking from more, from a jurisprudential view, I think civil liability is not merely a mechanism for separation, but also a reflection of deeper questions about justice, fairness, and legal responsibility. It can also say that it serves as a touchstone, as a kind of engaging critical legal theories that examine the foundation and purpose of law. Then, if I want to look at the fourth base of liability under the jurisprudential significance, and I don't know how to put it, but all I know is that fault-based liabilities sometimes describes as culpability-based or blame-oriented liability, which arises when a person's conduct, whether a wrongful act or omission or a negligent failure to act or omit, or maybe failure to act, results in harm to another. That's the concept. What I'm trying to explain, that the concept is a fundamental pillar of tort law that requiring the claimant to prove that the defendant breached a duty of care owed to them, as in leading to a compensable injury. That's when, I don't know how to, but as in looking at it in a natural law perspective, I can say that civil liability grounded in fault most reflects a moral basis for responsibility, like looking at a person, looking at a person in a way that how will I put this now? A person should only be held civilly liable if their conduct violates an inherent standard of right and wrong. The act of omission, looking at the act of omission that causes harm, looking at the act of omission that causes harm most not only breach a legal duty, but also reflect a failure of moral judgment. So what am I saying? Looking at civil liability fault under the positivity perspective, trying to bring it under the positivity perspective, I rather say that legal positivism approaches fault-based liability from a more formalist angle, as in the source of legal obligations is not morality, but the commands of recognized legal authority. So liability is justified strictly through adherence to written laws or codified standards. You know, a person can only be held liable for a wrongful act or omission if such conduct contravenes a specific status or legal norms. The focus is not on the moral blameworthiness of the actor, but on whether the law as enacted deems the conduct unlawful. As in looking at civil liability for sociological jurisprudence, you know, in that aspect, I can also say that it is an act or omission. I would like to say, okay, looking at the school of thought, this sociological jurisprudence school of thought places emphasis on the societal impact of legal rules and their practical operations within the social context. From a sociological perspective, I can say that civil liability for acts or omission is justified, not necessarily by moral or strictly legal standards, but by theories of law in promoting social cohesion and order. So looking at the sociology view is looking at an act or omission that becomes blameworthy or liable if it disrupts the smooth functioning and society of under nurtured expectations of conduct. I can actually look at it in another view that I can actually look at it on looking at case studies of fault-based liability in Nigerian jurisprudence. I can actually look at the case of Okonkwo versus and medical dental practitioners, where the appellant, Dr. Okonkwo, was disciplined for allegedly performing a blood transfusion on patients against her expressed religious belief. Then the patient, a Jehovah's Witness, had explicitly refused that blood transfusion, and her husband confirmed this position. Despite this, the doctor proceeded with the transfusion, believing it was necessary to save her life. The medical and dental
that's not the fact of Okonkwo. The doctor refused to transfuse her. The doctor refused to transfuse her with blood, even when the family members insisted he should do so, because the woman and her husband, being Jehovah's Witness, we are
No,
witness.
Prof, you are misplacing it. Oh. The man refused the transfusion. Even the husband confirmed it, but the doctor.
No. The doctor did not transfuse her with blood. Look, I have written an article on that case, so I know everything about it. The Medical and Dental Practitioner Disciplinary Committee found Dr. Okonkwo guilty of a breach of his duty or medical ethics by failing to transfuse her with blood when he knew that that was the only thing that could save her. The suggestion that they should transfuse her with blood was rejected by her and her husband. But our own relations, who are not Jehovah's Witnesses, we are insistent that anything that could save their sister or brother or auntie should be done. But the doctor respected the view of the woman and her husband and continued to watch over her, not being able to do anything to save her until she died. So Dr. Okonkwo was now tried in the Medical and Dental Practitioner Disciplinary panel and was found guilty. But on appeal, the Court of Appeal and on appeal to the Supreme Court, both the Court of Appeal and the Supreme Court discharged him of any criminal responsibility. That was what happened. So what do you want to draw from the case?
Yeah, this case illustrates how an intentional act, even if motivated by a desire to help, may attract liability where it contravenes the duty to respect personal autonomy and legal consent.
Okay, because the Supreme Court eventually heard that Dr. Okonkwo actually cannot, in deference to medical ethics, act against the wish, okay, of the woman and her husband. In other words, if she wishes to die, if blood transfusion is the only thing that will save her, so be it. You cannot say because medical ethics. What the Medical and Dental Practitioner panel, what he said was that Dr. Okonkwo could have referred her to another hospital or something. But the Supreme Court asked, for what purpose?
Yeah.
If you had already found that the only way she could live is by blood transfusion, for what reason are you going to refer her to another hospital? So that they will be able to force her to take the blood that she refuses in your own and all of that. So that was what happened in Okonkwo and Medical. And look, I lost many of the things you are saying.
See, Prof, this case
yes.
illustrates how an international act, even if motivated by a desire to help. Now, what I'm trying to say that even the doctor, even the doctor, even desire to help by trying to do it his own way, not trying to buy their own idea. You understand? So I say that the conduct of the doctor attracts liability, where it convenes the duty to respect personal autonomy and legal consent. So it's trying to respect his office, not trying to listen to the patient and what they are saying or what they believe in.
Anyway, we get your point, but go and read Okonkwo again.
Okay.
You've misrepresented the fact because the doctor actually did not transfuse her with blood. And it was his failure to transfuse her with blood or transfer to another hospital that Dr. Koko's professional colleagues were punishing him for, which the appellate and the Supreme Court said he cannot defer to your own ethics and violate and infringe on the personal wish of the deceased. Okay.
Okay. I'll
See,
be. I'll,
the major thing we want your group to tell us is that we have listened to the people presenting criminal law, and they have said fault liability is the most suitable basis of liability for criminal law. However, that you have a few strict liability offenses, as exemplified in traffic law and some other laws, and some few prescriptions of the criminal code itself. Okay? They have told us that after defining vicarious liability, which is a situation where somebody who is not even responsible for the act, let alone the mental element, is nevertheless found culpable because of his relationship with the actual doer, as we can find in thoughts of employees in the course of employment, or wrongdoing of wards and children when same is being asserted against their parents or guardian. Then, so they have said vicarious liability is really proper for criminal liability. They have told us that very few strict liability offenses exist, but that fault liability, by which we mean accompanying mental elements plus the wrongful act, would constitute 90% of criminal responsibility. What can you say with respect to civil wrong? For example, they have told us that vicarious liability is actually recommended. It's not recommended for criminal law. What can we say for civil law? Isn't it more appropriate for civil law? That's what we want you to tell us. Yes, it may not be good for criminal law because criminal law will require an accompanying guilty mind. But because of the emphasis of civil law, which is to look at the victim and to see how you can grant him relief, as opposed to criminal law, which is to look at the doer of the wrong and see how you impose deserved punishment on him. So, vicarious liability is not only more appropriate, it's very common in civil law. What does fault liability mean in criminal law? Fault liability simply means an accompanying guilty mind. But fault liability in tort means more than that, because you have as many torts that you can commit without the mental element. You have many torts that can occur through negligence. Okay? And so, Fault liability in tort is not exactly the same as fault liability in criminal law, because there are several wrongdoing known to civil law that will not require the plaintiff to establish a mental element. Okay?
Something that you can easily resolve and say, oh, go and do the correct thing. Or, oh, sure you understand. You go, yes. Why are you always doing something like that?
Maybe you want to.
Who is this one? Are you continuing with the class? So, Group 13, I have not read your paper, just like I've not read Group 12's paper. But this is what we just want you to tell us. We want you to tell us that which of the type of liability is more suitable and commonplace in civil law as opposed to criminal law. That's what we want to do. So the class members should take the two papers. The summary of what we want to hear, I have given you here. Fault liability in criminal law simply means accompanying guilty mind. And we said 90% of occasions when somebody is found guilty of a crime, there must be an accompanying guilty mind. The remaining 10%, when there is no accompanying guilty mind, is what we call strict liability. They are strict liability because the statutes have couched the offense in such a way that you don't need mental elements. And we said that most of the time you find such crimes outside the criminal code itself. You can find a few in the criminal code itself anyway, but most of the time you find them outside the criminal code. The implication is that other societal consideration overrides the need to have a guilty mind before conviction. And the presenters gave us examples, okay? The vicarious liability is when somebody is being held responsible for the misconduct of another because of its relationship with that other, okay? The typical example is employer-employee, when the employee commits a wrong in the course of employment. The other one is parents, guardians, and children or wards, when the child or the ward misbehaves, okay? And vicarious liability would ordinarily not be a commonplace for criminal responsibility because, as we have said, criminal responsibility is largely fault liability based. And the vicarious liability, as far as the wrong conduct itself is concerned, you won't be able to establish a guilty mind for the employer or the parent or the guardian, as the case may be, okay? Nevertheless, you have rare occasions when such a liability also exists in criminal law. But compared to civil law, vicarious liability is not only appropriate, but it's commonplace in civil law, okay? Especially that of an employer being held responsible for the wrongdoing of an employee is very commonplace and is also justified. So that is just the distinction we want to understand. The distinction between the application of those liabilities in criminal law and in civil law. Okay? So, class captain, we have paper 14, 15, 16, 17.
Yes, sir.
What is paper 14?
Hold on, sir.
Corporate everything.
Paper 14 is corporate liability in criminal law. And
Okay.
paper 15 is motive and malice in thoughts. And paper 16 is motive and malice in criminal law. It's 16, sir, not 17. 16. So we have 3 more papers.
Okay. We can take the 3 more papers next week. I hope
Yes,
the
sir, we
presenters
can.
will be around. I hope everybody who we permitted to join the class, you have been able to smuggle their name into any group.
Sir?
Have you been able to smuggle the name of the people we permitted later?
Yes, the ones that you gave your instructions that we should include.
I
Only
don't
those
want
ones.
anybody to come and disturb me that don't have score for. Do you understand?
Yes, I understand, sir.
Because these days now, the faculty wants us to be submitting postgraduate results almost immediately, even earlier than that of LLB. So I won't be looking for anybody who does not have a score.
Okay, sir. Noted, sir.
I won't want that to delay me in submitting results when my colleagues have done the marking. So see you next week.
Okay, sir. Thank you, sir.
Thank you, Prof.
Yeah, thank you, sir. Thank you, sir, Prof. Thank you, sir.
Thank you, Prof. Thank you, Prof.
Yes.
Thank you, Prof.
You're welcome.
Thank you, sir.
Yes, somebody was going to ask something.
I believe he was thanking you, sir.
Oh, okay. Thank you. I thank him too.